Good afternoon, or whatever time you're watching this. As you are probably aware, this is a training video on entering default judgments. What I started with is a quick Google search for a judgment checklist specifically for San Diego, and I saved it to Box. So this is the judgment checklist form here that you see on the screen. I did a search for Fresno as well, and it turned up the same document, only it didn't specify the county, but all of the requirements were the exact same. So if you want, you can do a quick search in the specific county, but if not, then this form is located on Box for you, and it's under Forms, Litigation, and Defaults, and then it's right on the first page of Defaults saved in a PDF version. To get started, you probably just want to go ahead and print out the checklist, so that way you can check things off literally as you're going through and doing them, as opposed to checking things and then this getting saved to Box when it's all filled out. So the first thing, I'm just going to run through this form quickly here, is it tells you that what you need to submit in order for default to be entered by the court. You need the original proof of service to be filed if it hasn't already with the summons and the complaint. A request for dismissal of any DOE defendants. The request for entry of default needs to be entered. A memorandum of cost, interest claimed on the judgment, and attorney's fees. Typically, this comes in the same declaration that would be submitted on behalf of Linden. It'll have an explanation of the interest calculated, and then anything as to why our client would be entitled to attorney's fees as well, whether it be by contract or statute. The remaining part of the checklist we rarely use. It deals with if there's an open book account. That's or accounting is one of the claims of the cause of on the cause of action. Any written agreement, the contracts between the parties would need to be attached as exhibits. Also deals with a fee waiver. If a fee was granted, then that would need to be submitted upon default as well. So those are basically the run-of-the-mill things, if you will, that you're going to be required to submit when you're looking to submit, default judgment by court. So first there, you will need to submit, once again, the original proof of service, if it, again, hasn't been done already. So let me just pull up what that would look like. So it looks like this. And I'm using an example from the case of Tusafar v. Robert Walters. So here is the proof of service of summons that was filed with the court. And it has the case number. And it is form PS010. If you ever have trouble finding the forms, they're all judicial council forms with the exception of the declarations. The form numbers are on the checklist here, and it's, so again, POS010 is the proof of service. So again, it's just a standard judicial council form, and you would fill it out as such. When you're doing your first default judgment, you want to make sure to pull several examples, at least 3 to 5 examples from box.com. But make sure, of course, whenever you're checking or filling anything out, it is particularized to the case that you're working on and not just a blatant copy and paste job. So going down the proof of service, you have the notice of the person served. They're served as an individual, not under a fictitious name, and the person who actually served the defendant. If if the proof of service was not originally filed because the defendant was unable to be served, then you'll need to submit the declaration of due diligence for substituted service. And that is, just trying to locate it here, 1 second. We have a affidavit of reasonable due diligence that's filled out by the process server, and you just would basically fill in our the attorney's name, location, all of the basic caption information, case number, and then this will detail the attempts the process server tried to make in service of the defendant. So that's another alternative if we never were able to submit an original proof of service. Next, after you've made sure that an original proof of service has already been submitted, you'll need to request the dismissal of any DOE defendants if that hasn't been done already, and that is Judicial Council Form CIV-110, and it looks like this. One thing I'll definitely warn you, there has been an occasion, that at least one that I've come across, where the case number as it was originally entered into the Judicial Council form was actually entered incorrectly. So the first time I'll pull a form for a case file with the case information already in it, I'll make sure to double check that case number, because it's easy to just look over something or skip a digit, and then your form is kicked back from the court. So that's always just kind of like something that I look at when I'm pulling out any forms for Judicial Council. So here's a request for dismissal, and you're filling it out, typically, not in this specific case, but typically it is with prejudice because it's a DOE defendant. They're usually unnamed. This case actually had a named defendant, so that's why it's filled out a bit more in regards to with or without prejudice here. Typically we have it as with prejudice. It's signed by Lyndon, dated, and that is it. So that is the request for dismissal. Once you've made sure that all the DOEs have been dismissed from a case, you're going to prepare and submit a request for entry of default. So this is Judicial Council Form CIV 100. And let me pull that up here. Okay. So this form can be a bit tricky because really it's a 3-in-1 form. This form can serve as your request for entry of default, as it does here. You can also request the same form for an actual default judgment by court or by clerk. In addition to that, that's that section 2 here is the default judgment. In addition to the default judgment or the application for default judgment, this form can also serve as, in section 7 here, your memorandum of cost, which will also be required to be submitted. Lyndon, however, doesn't like to use this form as a 3-in-1 because it can be a bit confusing. Because of that, we only use this form for the request for entry of default. So this would be the only box that you're checking when filling out this form. Now, there is a difference between the default by clerk versus default by court. If you look at the Judicial Council forms, it always gives you the CCPs that correspond to the form. And so I just did a quick Google search of CCP 585A, and that is what tells you what permits the court clerk to enter default. Typically, there are only cases on which it's a contract dispute and you're not asking the court to look for any or look at any additional evidence such as declarations. So that's what you see here. And it cannot be used for any personal injury cases. We don't have a lot of personal injury cases here, so it's not super relevant, but still good to know. So again, any contract dispute, by statute, the clerk, can enter default. If you're asking the court to take a look at declarations or any evidence or affidavits, then you're going to want a court judgment. So back to the request for entry of default and just going through it here. You want to make sure to have the date in which the complaint was filed, and just ensure that you're properly filling out the entire document. Again, leaving section 2, the judgment portion, blank, and making sure this is filled out for Lyndon, so all he has to do is add his signature upon review. Also, you're going to fill out whether or not this was you received any assistance or unlawful detainer assistance. Typically not. Here, you have your declaration of mailing as well. That will need to be filled out. And you need if you are to use this form as the actual judgment and not just the request for entry of judgment, you can only do so after you receive, first of all, Lyndon's approval. And second, if he has approved this form to be the request for entry of judgment and the actual default judgment by court or clerk, you'll absolutely need to fill out the declaration of non-military status, which you see here, it says required for judgment. The other reminder to that here is located on the judgment checklist, and it's letter D here, which, you know, again, as you're going through and filling out each of these forms, you're checking off everything that's already been completed or that you are and have just currently completed. So just a little tidbit there. After the request for entry of default has been filled out, you'll also need to fill out your memorandum of cost associated with the filing of the claim, and that is Judicial Council Form CIV 100. And that looks like this form here. So it's really simple form, CIV 100 or MC 100. Some of the council forms have different numbers, but it's the same form. And you'll just fill out the filing fees, if it went to jury food, deposition costs, if you've had to do a service of process, any fees associated with that, and any attorney's fees as well will be entered on the memorandum of cost as well. And you'll have Lyndon sign it, and the proof of service is on the back, so that's attached as well to be filled out. So the next part is going to be a 2-in-1 really, and it involves the interest claimed on the judgment and the attorney's fees. Just scroll up there. So that's numbers 5 and 6. So typically those are done in declaration by Lyndon, and we also like to have a declaration from the client as well. So the declaration of the client as well is actually used in support of a prove-up brief. You'll need to mail a prove-up brief once you filed your request for entry of default and that's been received. You'll actually mail a prove-up brief to the court. There's no associated filing fee, so you don't need to send a check or anything like that. And you'll pull several samples. It is a pretty boilerplate brief, nothing too honestly substantive. So you can feel free to pull, again, a couple samples that you find on Box. You plug in the client's information, and it's just a brief explaining why your client is entitled to default judgment. Once again, plenty of samples on Box. And in conjunction with the prove-up brief, you'll want to submit the declaration from your client. So you'll draft up the declaration itself, and you'll send it to the client for their signature. And so see here it says signature following, only because Lyndon prefers that the signature is attached separately and scanned in separately, excuse me, just because it makes the page look a little bit cleaner if you originally have it scanned in as a PDF, as opposed to only having the client signature attached to it here. It's a little fuzzier. I'm not sure if you can tell on the screen, but it's the exact same page, only this one has the client signature. It's a little fuzzy, but it's required that we have the client signature. This page is more clean and crisp, only it doesn't have the client signature. So Lyndon will require that you attach the client signature page separately, and that you do have a signature following, just for ease of the eyes there. So that is the client's declaration and the prove up brief. Now the prove up brief actually isn't on this judgment checklist form, but it is required in any default judgment. So next we have the the interest in the attorney's fees. So that's covered by a declaration for Linden, and it is pre and post judgment interest, including attorney's fees. So this declaration, again, feel free to pull several samples. This one is from 2SAFAR. Will explain how the interest calculations were arrived or calculated, as well as what grounds for which we are requesting attorney's fees. Here it was by contract, so that's quick and easy. Just throw it in there, and then you cite to the contract itself, and if you'd like, attach it as an exhibit. There is a master damage calculation spreadsheet. If you go to box.com, sorry, let me get to it here really quickly.